those who are handling, this is a group of insolvency professional, and many you handle these cases also, and you have experienced, even combined with the experience, there are 20 people there, means that the experience is very plenty. Then and there, if you want to speak specific to the topic, you can speak, and it is a workshop. Normally, workshop means everybody should participate. Yes, all the persons are equal in nature. Not only the presenter, even the participants also equal. Even we can learn from each other. That's the objective of workshop. Now I am going to discuss about the authorized representative roles and responsibilities with respect to regulation, particularly in real estate sector. The creditor in class segment we are going to discuss. I'll present my presentation. Hope my screen is visible.
Yes, sir, it's visible.
Yeah. Thank you. The topic is navigating the insolvency process, authorized representative and bankruptcy trustee perspective. And we are going to talk about only about authorized representative. Tomorrow, the other faculty, they may handle the bankruptcy trustee perspective. And within the authorized representative, we are going to talk about roles and responsibility of an authorized representative. So particularly understanding the critical function of an authorized representative under the IBC, especially in reference to real estate sector. Scope of this presentation, what we are going to talk in this 3-hour session. The number one is appointment and powers of authorized representative with respect to rules and regulations of IBC. How the selection criteria, what are the appointment process, what kind of powers AR have. These are all the things we are going to discuss. Another segment is detailed analysis of relevant case laws. There are, we are going to talk at least 10 case laws here. A few Supreme Court landmark judgment relate with AR and real estate case, High Court case also there, MCLAT case also there, and the NCLT cases also there. How it is relevant to AR, that we may have discussion on that 10 cases. There are hundreds plus cases are currently there. Even the NCLT orders, 100 plus orders are there. But we are taking only the landmark judgment relate with real estate and particularly authorized representative related proceedings only we are going to discuss. Then third thing is practical consideration and best practices of ARs. That's also we are going to discuss, particularly roles, communication tips, documentation practices, risk management, these kind of things we may discuss. And the recent trends and development in the role of ARs. That's also very important. When you all know that recent sir, even I think yesterday IBBI amended, I think third it is amended, it's uploaded in fourth, that means yesterday only. The authorized, apart from authorized representative, there is a person called facilitator. That facilitator also called as the insolvency professional only. That also we are going to discuss in this presentation. And there are quite discussion paper that is available in IBBI site. Even based on that discussion paper only, the facilitator now come in the real estate proceedings, apart from authorized representative. That recent trend also we are going to discuss. Now we will proceed with the presentation. These are the scope of presentation under 4 broad category we are going to discuss. Appointment of author, I think we all know it's all just a theoretical kind of thing initially. The appointment of authorized representative, selection of authorized representative, though the IRB may identify the authorized representative based on the preference of the financial creditor. Here, most of the cases, it is creditor in class category, particularly real estate sector. The AR is selected on the basis of high number of votes from the creditors, ensuring that the representative align with the majority interest. That is the selection process of authorized representative. IRB does not have the role of appointing the AR, but IRB have the role of identifying the authorized representative. That's the key role played by insolvency resolution professional. Interim, particularly interim resolution proposal and resolution professional. And role of the IRB, particularly here in this case, interim resolution professional or resolution professional or liquidator, the case may be. The selection process is on the basis of very transparent, very fair manner, how it is benefited to the particular creditor in class. That is very important. And application, then again IRP will apply to the adjudicating authority, here in this case NCLT. This step is essential to legitimate the appointment and allows the AR to start functioning in their capacity. Appointment order is required for authorized representative. That needs to be done by interim resolution professional or resolution professional or liquidator. That needs to be ensured by these professionals, and even authorized representative also need to ensure there whether he got the order. It should be mentioned in the NCLT order. The importance of AR role is very much. He or she is the liaising officer in between the financial creditor, particularly creditor in class, and the entire insolvency process. The person should have certain expertise, particularly even AR also insolvency professional. Naturally, that insolvency professional have that expertise. And the complexity of the case also he must know, particularly real estate cases. This is also theoretical aspect, voting by authorized representative. These are all from rules and regulation of IBC only. The authorized representative hold the responsibility of casting votes on behalf of creditor in class. He must work with the interest of the creditor in class, adequately voiced in the decision making, particularly COC meeting, because he representing the creditor in class. The voting he has a power, not individually. Anyway, the creditor in class will give the direction to the authorized representative. Representation of financial creditor. The AR ability to own on behalf of multiple creditor, we call it as a creditor in class. Voting process, it should have streamlined process. Before any voting, he should get concurrence from creditor in class. Because he is not work alone. He is for the people of creditor in class, the financial creditor. Here, they may be the home buyer or the home deposit makers. That's the representation, all the relevant points needs to be noted from the creditor in class, then represents in the COC meeting. And importance of authorized representation in decision making. AR is vital in corporate governance and financial, is as like similar like financial creditor, how financial creditor behave in a COC meeting with the interest of the financial creditor. The AR need to the informed decision, whatever the, he may not act as an individual. He is the representative of the creditor in class. He need to take care of all points noted in the creditor in class meeting. Replacement of author, even there are certain cases, case law also talk about those things. Replacement of authorized representative, it's the financial creditor authority right to replace the authorized representative. Here, in this case, creditor in class. If creditor, maximum creditor in class, maybe 100 or 200 creditor, 100 financial creditor representing by one authorized representative, even that creditor in class have the right to replace the authorized representative also. And it needs to be mentioned in the COC meeting through the IRP, RPR liquidator. The AR can be replaced. Role of IRP and RP in the interim resolution or resolution proportional, he is responsible for circulating the replacement request among the creditor and facilitating the entire process. The voting process also needed for once the replacement request is circulated, voting process is conducted among the creditor in class to decide on the replacement of the AR, ensuring a democratic approach in decision making. This is very much just like that. We cannot change the authorized representative. Then the IRP or RP or liquidator, he need to file the application to adjudicating authority. Then the adjudicating authority will provide a relevant order for change of replacement of authorized representative. Fees of, this is very important for us as an insolvency professional. Fees of authorized representative as per the regulation, minimum fees. Whatever they mentioned in this case, it is minimum fees. The authorized representative entitlement to get the fees. There are two kind of meetings he can attend. In the COC meeting, he can attend as a participant. Another thing is, he can conduct a creditor in class creditor meeting. There is one is attendance, participation. Another is he is one conducting the creditor in class. Maybe he is handling 100 creditor, then 100 creditor meeting. He is anchoring that meeting. Then that is another segment. There are one is participation in the COC meeting. COC means combined COC meeting. Here in this case of second case is he is maybe the anchoring person for the meeting of creditor in class meeting. That is also covered. The regulation also specifically mentioned how much amount needs to be given to in the both cases. And there are cases the multiple meeting may be required. The entire cost, the authorized representative cost is part of insolvency cost, as like IP cost. This is the regulation. Regulation number 8. It's clearly mentioned the minimum the fees per meeting committee, particularly the participation or the attendance in the combined COC meeting. All the creditor meeting. Then if the creditor in class have the size of the, if the AR is handling 10 to 100, then the fees is 30,000. If AR is handling 101 to 1000, then it is 40,000 fees per meeting of the committee, per meeting. And the more than 1,000 means, then the AR is eligible to get 50,000 per sitting, the COC meeting. Then another case is the AR is conducting a creditor in class meeting. That means wherever he may be the representative of 10 to 100%, he conducting the, before COC meeting, he conducting the creditor in class meeting, then the fees per meeting is 10 to 100, it is 10,000, 101 to 1,000 creditor if he is handling, then 12,000 rupees per meeting. More than 1,000, then it is 15,000 per meeting for creditor in class meeting. The point number C also mentioned that this, particularly the COC meeting, in respect to two meetings, particularly AR, first two meetings, he is authorized to get the fees per meeting. If it crosses two meetings, COC meeting multiple times happens, beyond 2 times, then the entire COC, because it's covered under insolvency resolution cost, then the COC approval is required. Anyway, nowadays all IPs are taking all the approval with the, because anyway COC have the power, all the expenditure. Then the beyond 2 meetings, the COC approval is required. The same in the case of the further additional meeting, the committee of creditor approval is very much required. Otherwise, he may not get the fees also. This is with respect to fees. And there are certain regulations, and we are going to talk about that regulation also. Point-wise, there are out of total regulation in CRP process, there are 11 regulations with related with the authorized representative. We are going to talk about those 11 regulation also in our discussion. The regulation purview, framework for selection of AR, that is there available in the regulation itself. Appointment guidelines, act like IP, yes, there is a similar kind of guidelines only. The one thing is he should not be a relative of the IRP or RP or liquidator. He must be a independent of the resolution professional or IRP. And functioning procedure also clearly mentioned in the, there are 15 points mentioned in the regulation itself. What kind of role he can play. That is clearly mentioned in the regulation. Replacement procedure also, it's clearly mentioned, and we also talk about the, just 2 slides back, we talk about how replacement can be happened. And also importance of fair representation. That is very much important. Even in IP also, IP role, either it may be IRP or RP or liquidator, the same kind of fair representation is required. Where he is not acting individually. He is even we can call it as he is the court officer. He behaves like a judge. He is not a judge, but he should behave like a judge. That means the fair representation is required, and with the purview of IBC and also the financial creditor interest also within the purview of IBC. Informed decision making, what it means, he should not take individual decision. He should take creditor in class preliminary review, then he can act based on their own guidance in the COC meeting. It's all clearly mentioned in the regulation. Framework of selection, it is particularly real estate cases, creditor in cases, it is based on the claim. Initially, IRP may look for the how much a claim is coming within couple of days. He may know No, particularly real estate case, if the creditor, number of creditors are more, then naturally IRB look for AR, minimum 3 based on the requirement of that case. It is based on the claim, number of claims. Identification of creditor classes. Whether if home buyer is there, then naturally it will fall under AR category. Then also, if there are, we are going to talk about Supreme Court, I think High Court, Supreme Court judgment related with it. There are two kind of classes in real estate sector. One is home buyer. Other than regular financial creditor like banks or NBFC, they are funding mean that is different. The home buyer and even the home buyer like a depositor kind of thing. So that also even one case talk about that also. Not only home buyer, another is home. Maybe later stage they may buy the property, but on deposit basis, on money basis, they may invest in that project as an individual. Then there also comes under creditor class. Then the formation of the committee of creditor with the AR and other creditor. Other means here financial creditor. Then selection of insolvency professional. The regulation allows 3, the RP or IRP need to identify 3 insolvency professional to act as a AR. They cannot be a relative of that IRP or RP or liquidator. Ensure unbiased representation. Public announcement requirement, even that is clearly mentioned in the even public announcement also, which if the case in creditor in class, that means the real estate case means the public announcement AR, that is the one, even we can see that form also in the even the public announcement, which comprises of authorized representative names also. It will be mentioned in the public announcement. It is in the under regulation 4A. It is clearly, we are going to see one by one all these 11 important regulations with relate with AR also. Even the public announcement itself, AR name need to be disclosed. Then the claims by creditor, submission of claim by creditor in an electronic manner. The Form CA also authorized representative name will be there. Proof of debt, that is very much important in this IBC case. Role of entering professional depending upon the class of creditor, he need to identify the AR. Then even the allocation of creditors to the particular AR, that is the role of the IRP and RP. After getting even who are all the financial creditor, the AR going to handle. That needs to be recorded. And the importance of electronic submission, the claim, that's all. Even prior appointment of AR also, that is possible. After appointment means AR needs to be here. AR may be the collection agent kind of thing only. He may not act like a decision maker. Even the IP also, the ultimate the claim, he can collect all the claims, but the claim validation or the claim approval has to be done by the NCLT, co-adjudicating authority has the role. Use of information utility also, AR has the authorization to get the relevant information of the corporate debtor from information utility. Claims this is claims by workman and employee. This may be the big corporate, they are having more employees. In these kind of type of cases also, we can appoint AR. Dues to workmen and employees, maybe 500 or 1,000 members, even 10,000 members are there, mean the AR can act as the representative of workmen and employees. Role of authorized representative as similar to earlier the real estate case. Usually the form E need to be filled if the workman and employee authorization given to authorized representative, then the form E need to be filled. Selection of insolvency professional, that's all a part of IBC process. Here form CA submission, authorized representative, importance of creditor in class, it's all there in the each and every forms as stipulated by the IBPA. Time to time, we as a IP, we should look for the any recent amendment happen, whether the form is changed. Now most of the things are in online. We need to check the recent amendment time to time. Application process to adjudicating authority, IRP needs to submit the details about the AR to the adjudicating authority with the timeline, stringent timeline. The applicant must be made within 2 days following the verification of, within 2 days of verification of claim. These things need to be put to the adjudicating authority and the relevant AR. And after adjudicating authority approval, all the verification and the again adjudicating authority approval, it's all required. That's the role of IRP. AR not directly involving with the NCLT for application process, but wherever, because he is the representative of financial creditor, wherever the creditor in class required any judicial reference, or he need to represent on behalf of financial creditor. For application stage, it is the role of IRP, RP or liquidator. He has the role. He or she has the role. Interim resolution professional role. I think we are discussed in the earlier slide also. There are implications. Delay in appointment. If the AR is not appointed, then what will happen? Nothing will happen. The responsibility is still lying with IRB, RB and liquidator. Then the headache, the IBC have given this provision. If IRP or RP or liquidator, he is not using this AR role, then the headache, or even we cannot call it as a headache, it's ultimately IRB, RP, liquidator. He need to take the responsibility of all the creditor in class. Any delay, normally after the regulation, it is T+23 after commencement of insolvency, after acceptance of admission of case in the NCLT, within T+23 days, the AR needs to be appointed. If it is delayed, then it is the responsibility of IRP, RP or liquidator. He need to, the AR role also he need to play. That means without AR also, the CARP process will continue. The communication process between the creditor, insolvency resolution, CARP process, COC, that is all nowadays in all full of electronic means of communication. Role of interim resolution professional play a vital role in these cases. Engagement between authorized representative and creditor in class is also very vital. Nowadays it's also done in electronic mode. If it is needed in person, the meeting can be organized by the authorized representative, particularly those creditor he is handling, creditor in class. Entitled means we already talk about the amount and all. AR is entitled to receive a fees. It is the acknowledgement for his work, and also incentivized for the work done by the AR. And fees is applicable for every meeting attended. This is clearly mentioned in the regulation. Whether it is a participation or the engagement. Participation means COC meeting. Engagement means it is he is conducting the creditor in class meeting. Payment is part of insolvency resolution process cost. Another important factor AR needs to work is agenda circulation. Introductions to agenda circulation. The role of authorized representative is before any COC meeting, he need to get concurrence from the creditor in class. It is better he need to use the electronic means, circulation of the agenda, and he need to get the preliminary views from the creditor in class. That's where he can enhance his participation can be enhanced in the COC, actual COC meeting. Preliminary views from the creditor in class is very much important. The AR needs to conduct a meeting with the creditor in class before any COC meeting if required. And preparation of committee meeting also. Whatever the creditor in class combined decision, he need to represent in the COC meeting, not his individual agenda. That is no way. We know that we are all the creditor representative. And expected outcome also, he need to circulate among, after the COC meeting, he need to circulate among the creditor in class. That is the minutes. That is very much. I think nowadays there are tools are available. If the meeting is recorded more, particularly by IRP or RPR liquidator, get that recorded version, convert it into minutes. Maybe they may circulate also, but if we are conducting creditor in class, same manner we need to prepare a minutes also. It will be very helpful when any litigation comes between the creditor in class and AR or the IRP or AR. Not normally it won't happen. Maybe the AR have the upper end. Otherwise, if the documentation is very, very important. Summarizing the key point discussed and the future course of action also need to be discussed with the creditor in class. Now the creditor, we talk about creditor preliminary view, the point number 4. Understanding the submission of process for creditor, time frame for submission. That is very much important. The last minute hurry-burry, we should not do it. Before the COC meeting, whether 24 hours before, because now even any meeting, if AR is represented, then the IRP or RP has to give minimum 48 hours. 5 days will be given in an emergency meeting also. If AR is presented, then 48 hours is there. Then the 24 hours, AR can get the preliminary view from the creditor in class. Then he can represent with the COC meeting. So open submission window also. Even the now the whatever the preliminary view, the electronic modes of communications are there. The AR need to get all the creditor if it is required. Creditor in class approval, it is required before attending the COC meeting. Meeting assistance. Role of authorized representative is point number 1, play a crucial role in assisting creditor with their designated class. And also the well-informed decisions occurring in the upcoming committee meeting, COC meeting. Facilitating understanding. Yes, many creditor in class may not have well-versed in the IBC process. It is the role of authorized representative need to explain all these things. Maybe the financial creditor, even certain cases, the other creditor, they may have the well-versed knowledge about IBC. Creditor in class, particularly home buyer case, the knowledge about IBC, it is the responsibility of the AR need to protect the interest of the IBC and also protect the interest of the creditor in class. And support with informed decision-making process. Everything should be with the assistance of creditor in class. Bridging the communication gap between the IRP process with the financial creditor in class. That communication gap needs to be fulfilled by the authorized representative. Encouraging active participation from financial creditor in class. It's all the role. Actually, it is a very crucial role. Even the IRB, RB, liquidator role may be different. AR role is something different because normally the creditor in class have lesser knowledge about IBC process, all the regulation, these things. Then the AR role needs to be very thorough in this manner. IRB, RB, he may face different challenges. But AR, because he is the representative of creditor in class, then particularly the communication between the creditor and class should be very, he should encourage the participation of creditor in class also. Here his role is only facilitator. He is not a decision maker. The combined decision of the creditor in class only speak in the committee of creditor meeting. Another important crucial factor role played by the authorized representative is evaluation of resolution plan. As like any financial creditor, the AR is the authorized person for creditor in class. Then if resolution plan comes means he need to evaluate, even in the all the evaluate, and he need to again discuss with the class of creditor what kind of resolution plan coming in that COC meeting after the expression of interest, what kind of resolution plans are coming. Then again he need to go to creditor in class. Then after get the concurrence from the creditor in class, he again discuss in the COC meeting, and the voting and all the rights by the financial creditor role, particularly his creditor in class, he need to take a right call. That's where in case of evaluation of resolution plan also, authorized representative needs to be as like a financial creditor. He need to do. Progress update on corporate insolvency resolution process. He need to regularly update the required information to committee of particularly creditor in class, and he is the authorized representative. He need to take the accountability of the communication gap between the CARP process and the creditor in class. The relevant periodical update is required. And particularly we can call it as a creditor awareness and engagement. He is like a AR is like a trainer kind of thing. Unlike IRP and RP, the role is completely different. AR role is particularly real estate case. It's like a creditor awareness and engagement that needs to be done. Any modification in resolution plan, that's also he need to coordinate with both the committee of creditor and the creditor in class, but ultimately creditor in class interest must be protected. And based on the creditor in class suggestion, he can give suggestion to the committee of creditor for any modification if required. And he needs to work on the basis of creditor needs, the class of creditor, their interest, the resolution, even any modification, again the AR need to go to creditor in class and then again represent in the committee of COC and also coordinate with the IRP, RP, the case may be. Meeting minutes preparation, that's already we talk about it. It's diligently we need to do. It needs to be recorded. It should not like we are just in between and we can hold it something like that, because IRP and RB liquidator have clear-cut role, and the IRP, RP and liquidator, they are frequently coordinating with the NCLT or the committee of creditor. Then in the we should not avoid the minutes preparation also. Even with the creditor in class meeting also, meeting minutes is required, as like COC meeting. The same creditor in class meeting also, similar kind of record we need to keep it. All the documentation process, full of electronic mode is advisable. Then only the authentication may be well and good. Currently, there are many tools are available. AI tool, blockchain tools are there. There are plenty of organizations currently providing these things to IPs. IP may be IRB, RB, or liquidator, or AR. We need to get those kind of things. Maybe if the committee of creditor accepted the cost also, that needs to be checked. Otherwise, we cannot spend our own money on all these process. Everything need to be approved by the creditor in class. If it is in the decision of creditor in class, if it is in the case of COC, then COC approval is required. For the digital documentation cost, something like that. Even digital documentation is not there for AR, then there is no other way. Physical documentation is mandatory. Representation in tribunal. When AR, authorized representative, can represent in tribunal, he is the representative of creditor in class. Anyway, as like a financial creditor, he should act on behalf of the creditor. That's why he need to observe what kind of NCLT order we got it, and what kind of cases are going on. If any other person file the case in NCLT or in NCLAT or whatever the code, relevant code, then the AR need to be updated. And even if required, he can also present. And engagement with the regulatory authority. Here in this case, NCLT, even IBBI. Class representation, that is very much in between. From tribunal, COC, and all the CIRP proceeding, his representative, he is act like a financial creditor. Legal framework compliance also he need to wherever it needs as per the guidelines of IBBI regulation. Advocacy and support also need to provide to wherever possible. Necessary support to tribunals also. We are not supporting tribunal. It's the order. We need to obey. Additional responsibility. Creditor can propose additional responsibility. During the course of CIRP, the creditor in class may provide external, they may give few suggestions. That needs to be taken care. And whatever the additional responsibility, he needs to fulfill the expectation and needs of the creditor in class. The important attitude, what we can say, flexibility in representation, because he is a mediator in between the COC and creditor in class. The flexibility need to be there. Enhancing accountability, both the sides. COC also accountable, and the NCLT also he is accountable. Creditor in class also he is accountable. Then he should be maintain high ethics, high standard in his practice. And he always encourage active participation. Again, we are repeating, because the creditor in class, most of the cases, home buyers are creditor in class. They may not have the IBC knowledge. That is the responsibility of AR we cannot call it as a educate, but informed, and we need to get the concurrence from the AR. There is a special case, committee with only creditor in class. There is no other financial creditor. That means banks, NBFC, or the operational creditor not there, or the other creditors not there. Then what will happen? The composition of committee consists of only AR. AR, maybe the coordination by IRP, RP, or liquidator. That means the committee of creditor meeting, the committee of creditor is full of ARs. The AR is he can whatever the creditor in class, interest, expectation, that he can discuss. The implication of debtor, even in this case, the ARs act as a pure financial creditor. The creditor in class representation only there in the COC meeting. And the eligibility criteria remains same only. And whatever the class he is representing, whatever the IP eligibility criteria, it is applicable to AR also. Class composition also. Maybe the particular class 10 to 100 or 100 to 200, whatever the number it may be, whatever the person he is representing, maybe the voting percentage may vary. Maybe the 4 or 5 ARs representing. Then the weightage of crediting vote share may be different depending upon the depth. Then he need to act based on that also with the interest of the creditor in class. The meeting notice requirement, we all know that 5 days notice period is required. If it is 48 hours, then he need to conduct within 24 hours, he need to conduct creditor in class meeting if required. Voting process, we already talked about on behalf of financial creditor in class, and he need to comply with the legal compliance. This is very important. The importance of appointment order, that is very much that's a formal mandate. Yes, anyway, IRP, RP, they may put 3 AR name in the NCLT. The NCLT order is very important. The AR name will be mentioned. He need to keep all these records. Nowadays, it's all there digitally. And wherever the legal basis, the legal foundation, the appointment based on the legal foundation, he needs to obey or consent need to be given. And evidence of authority, because full of the IP process is full of documentation. The appointment order also very much important for to act as an authorized representative. Powers and responsibility of AR, that's all we have already discussed. Voting right also we already discussed. Communication with creditor, that's maybe we already discussed. That's why again I'm not talking, because this presentation based on point-wise regulation. Access to information also, he has the right to access information from information utility, the banks, NBFC. He has the access to right to access information from various sources. Types of information, the critical information, even the statutory authority also, he can get the information. The meeting minutes also, he has the right to get the meeting minutes. Purpose of access to information, that's also based on the negotiation and resolution between the COC meeting, IRP, with the discussion with the IRP, he need to access everything. Potential restriction on access also. That's also certain type of sensitive information, particularly if it involves confidential business strategies or proprietary data. That needs to be, the access is restricted. Even if he is holding, he should not share with anybody else. That access to information is key role played by the AR. confidentiality. Understanding the confidential critical role of confidentiality is very much important. Duty of confidentiality as like IRP, RP. Even those who are involving in this all the insolvency resolution process, the confidential the sensitive information during the process, he need to be very he need to keep the confidential matter as it is. And also the importance of confidentiality is very important. If it is breach the confidential information, if it is found AR misrepresented or breach the guidelines of the adjudicating authority, then it is punishable under Act. That's why confidentiality is very much needed. There are certain limitations. That's also very important. Limitation on authorized representative powers. Defined by appointment order. Based on the appointment order, his role is there. Already regulations also there. Cannot exceed mandate. Other than the regulation, other than the mandated work, he cannot do extra work. Action requiring COC approval. Something like asset sales or restructuring decision may need COC consent. He cannot take his own decision. There are certain action required NCLT approval. He cannot take his own decision. Wherever possible, then the AR through IRP or RP, the NCLT approval need to be done, or otherwise, on behalf of creditor in class, he can represent with the NCLT and get the approval. That means he cannot work as an independent. He need to work with the existing stakeholder. No management control. The management control is under the RP or IRP or liquidator. No management control. AR role is just a mediator. Even the IP role also same. The COC approval, wherever possible, the COC approval is required. But anyway, the company day to operation anyway handled by the IRP, RP are liquidated. But AR does not have any role because he is a financial creditor. That's a certain limitation is there that we should know. Duration of appointment. How long he can work like a authorized representative? The one is end of CARP. That is one point. The corporate insolvency resolution process is over. Then AR role is over. Then the removal by NCLT because of some various reason. It may be conflict of interest or misconduct or the any accountability issue. Then the removal by NCLT also possible. Resignation also. The AR is unable to deliver his duties. He can put up resignation through IRP, RP or liquidator, but it must be communicated to NCLT. He need to. It is the responsibility of AR. Though he may communicate through medium, but he need to ensure that even if he is put up the resignation. Clarity on duration, how long he is working, that is very much important. Otherwise also, because his fees is based on sitting fees, meeting fees, either as a participant or a engagement with the creditor in class. The based on that, the clarity of duration should be very much required. And maybe we can go through the recent notification, that is on 3rd February, just 2 days before, IBBI circulated one amendment. It is related with real estate. What it means now it is with immediate effect. Even whatever the cases upcoming coming or whatever the if it is required, then this amendment is relevant. It is role of the word call it as a facilitator. Facilitator. we are calling it as IRP, RP, liquidator, and the AR. Like AR, there is one more word used by the regulation, that is facilitator. Facilitator also insolvency professional. Wherever this is new regulation, just amendment happened 2 days back. The regulation number 4E, actually 4B is appointment of authorized representative. 4 is handing over the possession. There is 60% of the votes is there in the real estate project. Then if the class of creditor is exceed 1,000, up to 1,000, there is no need of facilitator. That talk about the regulation 16C talk about appointment of facilitator. Facilitator also insolvency professional. If other than AR, other than even class and class in the financial class of creditor, apart from class of creditor, maybe the 1,000 plus means the AR may be multiple, maybe 10 AR is there means the one more facilitator for the entire project is also even the one or more facilitator, that is depending upon the size of the case. That means it is new amendment. Other than AR, there is a person called in particularly real estate case, the facilitator. That is appointment of facilitator. The regulation 63 talk about appointment of facilitator. His role is he is also the mediator between all the ARs, and he can participate but not vote, and also his fees may be very less when compared with the AR. As per the regulation amendment, the facilitator fees is capped at 20% of the authorized representative fees. That means we already talked about 2 cases, meeting fees as a participant, as an engaged person. Then this case facilitator may fall under the engaged kind of thing only, or the wherever possible only participation. Then 20% of the authorized representative fees will be given to facilitator. That means facilitator fees is lesser than based on recent amendment, maybe later stage, based on because this is just 2 days regulation, based on experience, IBBA may amend extra fees also. There is a possibility, but this is a new term. The facilitator word is a new term in IBC. Just 2 days back amendment. You can go through the IBBA site. The amendment is already updated in the regulation. And the facilitator replacement also possible as like AR. Roles and responsibility of facilitator, he is the communication person between the AR and the creditor. Because the case is, the creditor in class is 1,000 plus. It is the facilitator is applicable only the creditor in class have more than 1,000. Then only it is applicable. Based on this amendment, real estate project regulation also, the regulation 18 update, the Real Estate Regulation Act also involved. Whatever the committee invites the competent authority from real estate regulation and development. That means, what it means, the person from the regulatory authority also, one of the, he can attend the real estate project COC meeting. He can attend, not vote. That is why these kind of amendment came in the picture. That means if it is in the case of the real estate regulation and development, something like any regulatory authority from government side or state government side or central government side, from the registering authority or the regulatory body, they also can participate in the meeting. That is a new amendment as per the Real Estate Regulation and Development Act 2016. This new amendment, this is first in kind. and the competent authority from the regulation, here in the case of maybe the registering authority, they may be the whatever the quasi government or the government, they may be the part of the COC meeting as a participant. And 30C, regulation 30C amendment, detailed report needs to be prepared by the resolution professional with respect to real estate project. Necessary approval needs to be mentioned. The RP or IRP need to get necessary approval from the proper regulatory authority. And the status of this development rights and permission. That means if any construction is going on in the real estate project, the relevant development report also, what stage it is there, and the viability of the project also needs to be provided by the RP. And submission process. This is it needs to be submitted to adjudicating authority within 60 days of commencement of insolvency ICD. That is this is new amendment. And monitoring and miscellaneous provisions in this amendment. Regulation 31, stipulating the fees payable to the facilitator under class of sub-regulation. Here we appointed a facilitator. Facilitator fees needs to be mentioned. And amendment to regulation 36, it's talk about adjustment in class, interest. Interest means home loan interest. That means somebody invested money, maybe the home buyer. There are two classes of home buyer. One home buyer is given certain amount, and maybe after 36 months or 24 months, the allotment may happen. Another people is the home depositor. That means they may provide money without the allotment, something like that. After 3 years, this building will be provided, not like that, something like a deposit kind of thing. If that is in the case, interest is applicable. That is mentioned in this regulation. And currently that interest rate is 8%. Even if it is the cases comes to IPC, then the home depositor, that means that they are also equal to home buyer, home depositor, they are eligible to get refund along with the 8% interest. That amount also, there are many cases, even we are going to talk about that case law also in the coming slide. What are the 10 case law? One case is talk about the interest. Even the home buyer withdraw the option of allotment and want of money back, then he is eligible to get 8% interest. That is now clearly mentioned in the regulation. That is not there in previous IBC regulation. That's a new amendment. These are all the regulation point. Even now we can go to the amendment. I think let's see, I think one minute. I'm now going to talk about all the 11, whatever the regulation available. Hope my screen is visible. These are the regulation, because point-wise regulation also. There are the whatever the amendment, everything is there, except the new amendment. I did not put it here, but you can go through. That is, I think, 7 page, literally 4 page regulation is there. Along with the translation, Hindi and English, it is 7 to 8 pages are there. You can go through that regulation. That is a new amendment. And based on the regulation, this also we already know in theoretically, choice of authorization. Just I am go through where which regulation is there and the topic only I can read it, because already we covered with all these points in the presentation itself. And now what are the legal points there in the regulation, that the headline only I'll read it. The point number 4A, choice of authorized representative. How IRB can decide ARP is needed. That is mentioned in the regulation 4A. And public announcement. Point number regulation number 6. Public announcement under point number BB. Offer choice of 3 insolvency professionals identified under regulation 4A to act as the authorized representative of the creditor in each class. That is there in the regulation. That is regulation number 6. Then regulation number 8, section, not section, regulation 8A talk about claims by creditor in class. That is even the creditor, wherever the point number 3, the creditor in class mentioned, authorized representative is responsible. That is there in the claims by creditor in a class, the form CA, even form CA, the name, the authorized representative name need to be mentioned. This is claim by creditor in a class. Claim by workman and employee, that's already we discussed in the PowerPoint presentation. That is form E, that is under regulation 9. Claims by workman and employee represented by authorized representative. That is there in the regulation. Then this is new amendment 16A. Authorized representative, form CA, again the same form CA only. Need to get the adjudicating authority approval also. Appointment of authorized representative. That is the responsibility of IRP, RP, and the liquidator if required. And it is the responsibility of authorized representative to get the order. There are certain roles and responsibilities given to IRP, interim resolution professional. So there are there is a even we can say it is a roles and responsibility of IAR through IRP. The regulation points are there. The fees already mentioned in the regulation, already we saw in the presentation. These are all rules and regulation. I think you can, I'll maybe, because the regulation may be many. With respect to only AR, I combine this. I'll put it in the chat box after maybe before 10 minutes of this session. You can, if required. Otherwise, anyway, regulation it have all the things. Particularly with respect to AR, the relevant regulations are there. Only pertain to AR. Committee with only creditor in class, that is presented in the presentation also. Only the authorized representative. That amendment also regulation 16B. And regulation 19, it's talk about the meeting notice, 5 days notice period. The authorized, if the authorized person there in the committee of creditor, then 48 hours, minimum 48 hours is required. Normally 5 days. If it is urgent, even urgent also, without AR, they can, maybe COC meeting can be done within 24 hours. But if AR is present there, then minimum 48 hours. That is there in the regulation and voting by the committee. How that's all we talked in the presentation also. And voting by authorized representative, how he has to cast his vote in respect to the creditor in class. That is the regulation 25A. These are all the major regulation, and whatever the forms A with relate with the authorized representative, it is all there. Form A also. Form AB, the written consent as act as authorized representative, that need to be given by AR to actually IRP. Submission of claim by financial creditor in class with respect to even these things. Either it may be a creditor in class themselves they can provide, or otherwise through AR they can give. And the timeline also, Form E, workman and employee, finally the timeline, that is the application of appointment of authorized representative after ICD, insolvency commencement date, the AR need to be appointed within T plus 2-3 days. It's all there in the regulation. I'll put it in chart box before the session conclusion. Now we are moving to the presentation, particularly case laws. Hope my screen is visible. Anything we want to discuss? Maybe there are many experienced persons are there in the call. Anybody want any more discussion on the? I can say it's a theoretical part. Now only we are going to discuss about the practical cases. Anything you want to ask? I think if anything more we need to discuss. It is well and good. Anybody want, maybe you want to share, maybe you may act as a AR in your assignment also. If you want to share anything related with this last 1 hour 15 minutes, you want to add further with your own experience, please let me know. Otherwise, I'll go to the judgment. Understanding the impact of authorized representative in court landmark judgment. It may be Supreme Court, High Court, NCLT, NCLAT. These things, there are almost 10 cases we are going to discuss. There are certain cases, the few landmark cases we are going to talk about in detail. There are few cases, just these are something like that. And there are maybe during, I'll provide, there are 50 one PDF covering the landmark judgment related with real estate and authorized representative. I'll give that things also, not in this presentation. All the 50 cases mean it may take time. What I will do, I will share. I will share the document to you. Now, this is the case number 1. I think you all know that this case is very crucial case before this authorized representative in place. Because of this case, AR and even real estate case itself comes in a different amendment. First, Union Bank of India. Supreme Court recognized home buyers' right under IBC. This writ petition, the case number 744 of 2017, even the initial period itself, Chitra Sharma versus Union of India, The case relate with the JP Infratech Limited. The case originally with Allahabad, now the Allahabad NCLT. The insolvency proceeding invitation happened because of under section C. Few of the creditor raised the application with the NCLT, and the CRP, during the CRP process, even IRP appointed, call for creditor claim, then come to know that there are other creditor. Here other creditor, that time it is a home buyers. Even the IRB does not know which, whether they can participate in the COC meeting. That's all questionable. Then the case went to NCLT. Even NCLT also given against the judgment because IBC does not have any provisions. That's where this is interesting case. And under these section 6, 7, 10, and 14 and 53 of IBC rules, the Chitra Sharma case, the court order forensic audit, then there are even the related party applied for resolution things, even court order certain deposit from the corporate debtor, where this total amount involved is 8,000 crore. The grievance of home buyers is ignore initial stages, limited because of limitation of IBC, and also impact of section 238 of the IBC also adversely affected the home buyers. The volume of grievances and respondents are very high. 646 home buyers with the responses of the JAL, Union of the Government of India. The case is widespread, and investment, whatever the investment done in this residential project, it's also gets affected because the home buyer given the money, the real estate company constructed a house, but the home buyer rights not fulfilled. The RBI also declared these 8,000 crore JP Infratech real estate company comes under the severe NPA cases, the default cases. Court interim direction. Here, the particularly Supreme Court direction. There is a Article 32. Article 32 was violated in this case. That's where the home buyers went to Supreme Court, and the Supreme Court again suspended the NCLT stay order given, and then management control handed over to IRP. Representation from home buyers allowed. Deposit requirement from JAL, they are the related party of the construction, that company. Supreme Court ordered 2,000 crore immediately need to be deposited in the separate bank account, and the prohibition of director leaving India also ordered by Supreme Court. Legal proceeding against JL also continued with the objective of protecting the home buyer interest. Then ongoing financial disclosure requirement, extended timeline also given, because this case initial period 2017 case, and Supreme Court advised create web portal because 650 around 650 home buyers are there. Supreme Court ordered for web portal for home buyers because sharing of information can happen across the class of creditor, here in this case home buyers, and the evaluation of amendment, and because of this case, Supreme Court come with certain judgment, and simultaneously IBBI amended, even the IBBI amended the regulation, the rule also included home buyer also considered as financial creditor. And the deposit and compliance issues also there. Whenever Supreme Court ordered 2,000 crore, you deposit, but initially they deposited only 100 crore. Then later increased to 750 crore. That kind of the tiliness happened. Then there are few cases, the home buyer asked for refund of money. That also happened. Then based on that IBC frame, home buyer rights, based on the Supreme Court judgment, IBC framed the regulation. Home buyer also considers a financial creditor. That all these provision comes, even we are discussing on AR, we are discussing on real estate case because of this case, Chitra Sharma case. It's something like it's a very big case. Even the almost all put together, all the order put together, something like there are 60-page order is there, 100-page order is there. If all put together, it is something like 200-300-page order related with this case alone. Because of this only, the AR concept is authorized representative concept came, creditor in class concept came, real estate amendment, many of the real estate amendment act came, everything because of this case only. And it is the watershed movement for home buyers in India. Then simultaneously, many cases, now almost, if we, I think around 6,000 case since inception, the case CARP admitted, around 30 to 40% of the case are now real estate case. It's because of Chitra Sharma case, many amendment happen. The significance of amendment, definition of financial creditor changed. Home buyer also considered as financial creditor. Financial debt also, because home buyer, whether it is considered as a debt, how it is considered as a debt, that definition arrived. Initiation of corporate insolvency resolution process by the financial creditor, that also home buyer also now allowed to initiate the CARP process. And the role of committee of creditor with the representation of AR, impact of the amendment on home buyers, that's all happened. Legislative intent behind the amendment is with the interest of home buyers. And judicial oversight and resolution process also happened because of Chitra Sharma versus Union of India. This is very interesting case. I think you may all know all these things, but if we forget something like that, this is because this is a landmark judgment. Whenever we have a doubt on AR, whenever we have a doubt on home buyer, because there are sub cases are there in this case. It may be while we are in practice, this case guideline may be very useful. Not only for AR, it may be useful for IRP, RP or liquidator, particularly those who are handling real estate case. Another case is Amarbali group case. This is interesting case with respect to real estate. That case talk about there are the project is stalled and because it may not continue, then the home buyer need to get the refund. How the home buyer can get refund? AR also, the role of AR also is there, because the AR is the representation of the class of creditor. AR role is there, but it talk about If the fund is refunded, then what is the impact? This case talk about, this is also Supreme Court case, the Amrabali group of company focusing on interest rate and compliance issue, because the project not took place. Home buyers given money, how the refund will be happen? The case, the point of initiation for the order dated initiation of admission of CARP, it is on 10/6/2020. Then the application by ACE group, they are asking for interest. Then discussion on applications, various applications. There are one more application by Super group application. Contempt petition also attempted. Rate of interest discussion. But nowhere the IBC talk about the interest rate on refund to home buyers. That's where the discussion happened. The Amrabali group case. The final judgment is the home buyer need to get the interest because many of the Company Act definitions sections, it is 8% is mentioned. The court took the decision of that's a landmark judgment. The interest rate 8% need to be given to the home buyer for the purpose of refund. This is also initial stage cases. How the interest rate is come, how the what are the procedure for refund of home buyers, everything given in this order. And another judgment relate with the Pioneer Urban Land and Infrastructure Limited versus Union of India. That is also Supreme Court case. This case talk about, this is also, because many home buyer got affected. This is almost 2019 case. The core issue, same, what Chitra Sharma case, same kind of issue also against and the project is a delayed project. The same kind of JP Infratech case kind of thing. The project is delayed and the home buyer in stake. The amendment to IBC happened in based on the Chitra Sharma case happened in 2018. Post 2018, the after amendment, this is the first case. The argument by Pioneer Urban Land, again, though the Chitra Sharma case is reference is there, then again they are talking about Article 14, right to equality, right to practice any profession. That means the NBFC bank only the financial creditor, not the home buyer. That kind of discussion argument happened in this case. And constitutional rights are also at stake. They are all, it's talk about constitutional right, concern over frivolous litigation, the urban land and infrastructure, they put case like this, the frivolous, the home buyers are not the financial creditor, they may be the other creditor, something like that. They may not be part of the COC. These kind of discussion happen. And it's affected real estate market also affected the decision of the it affected the home buyer's interest. Then the judgment came as like Chitra Sharma case, the home buyer interest is protected. The legal argument by the petitioner, urban land development, the validity of the code, whether the home buyer is the financial creditor, whether they are lending the money to the construction company. The home buyer is not financial creditor. These are the legal argument by the petitioner. The violation of the constitutional rights, impact of the real estate sector. They highlighted if one home buyer problem came, then the entire project is maybe CRB put in place. That kind of things also argued in the Supreme Court, Honorable Supreme Court. And finally the judgment came, home buyers as financial creditor, and the protection of home buyers' rights also Supreme Court take the decision in favor of home buyers. There are no violation of constitutional right. Judgment on the Delhi High Court also reference, because this case many because of the constitutional validity, High Court and Supreme Court only handle the both Delhi Court and Supreme Court cases are there with relate to these pioneer urban land. Previous litigation not there. That's the judgment thing. Overall, based on these three cases, the cases of Chitra Sharma, Amarbali, and the Pioneer, the landmark cases, significant, because whenever we want reference, these three cases may be the reference. Judicial outcome, particularly constitutional validity of the code, whether the home buyers are financial creditor or the other creditor discussion, whether they are the lender, whether they are the home buyer refund interest is needed or not, then we can refer these three cases. Nowadays, all the the litigation with the NCLT, any cases come, these references are given by the IP, even the representation by the committee of creditor. These cases are now reference for upcoming cases. The key takeaways on authorized representative in the Supreme Court cases. Indispensable role in judicial process. AR also based on the landmark judgment. The AR is a indispensable role in judicial process, particularly real estate case. Ensuring fairness and justice, because appointing AR, because only the time within timeline we can complete the process. Another thing is the creditor in class, or we can call it as a home buyer, their interest is protected based on the Supreme Court judgment. And critical function and legal framework, AR also comes under the legal framework. And the AR also, the judicial outcomes also part of judicial outcome. And importance of, even if you are putting NCLT cases and put authorized representative, that case, appointment of authorized representative, then any dispute with authorized representative, there are many cases are there. I found it, there are 30 plus cases. The case application is related with only authorized representative, not with any other issues. That's all. There are 30 plus cases are currently there. The importance of competent representation also, now enough cases are there. That's the key takeaways on authorized representative in the Supreme Court. Now the case number 4. This is Akshay Social Welfare Society versus Saha Infratech Private Limited. These both the parties involved. The timeline, this case, CRP started on 2020. 1st June 2022, only the appeal came. Claim rejection impact. This case relates with real estate. Claim rejection impact to safeguard the home buyer interest. Committee of creditor, 70% of the committee of creditor involvement in financial adjudication. Legal consent also, because if the home buyers are very limited and the financial, that means the bank and NBFC, they are very high, means it should not affect the home buyer thing. This case talk about that thing. There are IRB respondent 2-3 were rejected. The application for imbued by appellant was also rejected, prompting the current appeal. Here the authorized representative role also mentioned in the Akshay versus Saha Infratech case. The legal framework, it talks of, talk about legal framework also under section 21 of 6A, under 25A of IBC code, enough code, what kind of role the AR need to play, that is there, and the functions of class of creditor, particularly the AR role, that is clearly mentioned in this case, and limitation also mentioned in this case. AR already we discussed in the presentation. AR will not supersede or oversede or mandate something other than what his role, he should not do it. Then implement application on their own without authorized representation. That's also possible. Judicial interpretation. Even that is also in this case AR, that means authorized representative does not have any role on claim verification. Even IP can collect it and need to be put it in NCLT, then NCLT need to give final order. AR does not have any role. That's also interpretation given in this case. And the resolution, the NCLT also right to heard despite AR role. That's also discussed in this case. Whenever we have a doubt on the functionality of the authorized representative, yes, in this case there are certain role other than the AR role played by AR. That's where the honorable NCLT given the order. That is discussed in Astray versus Saha Infratech case. That means something like dispute on the AR responsibility. That is discussed in this case number 4. Tribunal decision and implication, understanding the impact on creditor and CARP. That's also part of this case only. Appellant participation affirmed. Reinforcement of creditor rights, again, though AR cannot supersede. Classification of creditor also reinforced. Significance of CARP, lessons on authorized representative role, protection of creditor rights, balance of procedure and rights, judiciary role in fairness. That is ensured in this case. This is the case number 4. Anything related with AR conflict, then we can refer this case. Akshay Social Welfare Society versus Saha Infra Tech Private Limited case. Then Vani Commercial Limited against the Max Heights Township Project Private Limited. This is simple case. The NCLT Delhi, court number 6, this case identified. Order was given on 2023. CRP initiated. Interim resolution professional IP Varun Koyal appointed as IRP. Public announcement, it's a recent case. Public announcement also made on 2023. Class of creditor classified. Estate allottees, home buyers under the regulation. Authorized representative proposal was proposed by the IRB, put it in the NCLT, and there are during claim verification, there are total 12 claims from allottees were verified. Another IP, Rakesh Kumar Gupta, as appointed as authorized representative. Why I mentioned this case? How AR appointed, that is mentioned. This is appointment of AR. That is discussed in this case. That's why I put it this case also one of the landmark judgment. The Rakesh Kumar, the key judgment and observation, majority support for appointment, 91.13% voting share for AR appointment. CA Rakesh Kumar Gupta as authorized representative for the 12 creditor in class. That is majority support also obtained, and compliance with requirement by IRP. And also he has valid AFA authorization for assignment AFA and appointment confirmation by NCLT. Mrs. IT Rakesh Kumar appointed as the authorized representative. This case talk about the requirement of AR appointment, significance of AR in insolvency process, majority consent because 91.13% approval uptake, and role of NCLT in approving AR appointment. That is clearly mentioned in this case. Case number 5, we talk about the appointment. Case number 4, talk about, again I am repeating because we should remember there are certain, because each case have unique identity. First 3 cases, it is related with the IBC validity. Then whether the home buyers are financial creditor. The case number 4 is dispute. Because AR dispute, it talks about because the AR supersedes certain actions, then the judgment given on against the AR work, something like that, given in case number 4, X-ray versus R. And this case number 5, it is appointment. Clearly discussed, the AR appointment is mentioned in the order. Then the case number 6, role and appointment of authorized representative. I think we can have 5 minutes break. Now 4:15, we can join 4:20. There is a 5 minutes break. We'll discuss after 4:20.
Okay, sir.
Okay, sir.
Can we start?
Okay, sir.
Yeah, great. I think Ankit, you put up we will provide these PPT, even the, maybe before this session, I will put it in chat box. Whether one thing, another thing is I will hand over not only PPT, relevant regulation and other recent amendment, everything I will forward to ECSI, then you can get it from them also. Whatever the presentation, whatever the regulation is there, I will put it in the chat box before 10 minutes of the session. Now we can go to presentation. This is case number 7. Between Vijay Kumaran versus Thompson and Sons Builders and Developers Private Limited. Case history is it is happened in Kerala, Kochi. The order was issued on July 22 under the CARP. Application filed, the application was submitted by the RP, appointing authorized representative for two distinct classes of creditors. Two distinct classes of creditor. One is home buyer. This is the first case talk about home buyer and deposit holder. That's where this case is unique. Vijay Kumaran versus Vijay Kumaran versus Samson and Sons Builders and Developers Private Limited. Normally we call it as a home buyer. There is a one class deposit holders. The classification was based on the records of corporate debtor, ensuring that interest of both the creditor group. Home buyer also financial creditor, deposit holder also financial creditor. That discussion, that argument happened in this case. Appointment and there is a home buyers handled by one AR, home buyers are handled by one AR, deposit holder handled by another AR. That also followed in this case. And the role of authorized representative as same as in the earlier appointment procedure of AR. The communication with the creditors through AR is done. This case, the uniqueness of this case is home buyers and deposit holders. Where normally the real estate case only home buyer. Here in this case, two separate versions. The home buyer, deposit holder, there is no allotment or the future allotment date, something will not be there, but they invested money. At the end of the project, they may get the home allotment or fund with interest. That is the scenario. They are individual investor, deposit holders. This case talk about those things. That deposit holder also handled by the AR. Analysis and the impact of this case. Importance of appointing AR for distinct classes of creditor in CARP. Particularly authorized representatives, those for home buyer, those for deposit holder. NCLT decision, Kochi NCLT decision to appoint separate AR for home buyers and separate deposit holders. That's an important decision. The resolution professional must adhere the procedure as per the IBC. They cannot avoid deposit holder or deposit. Sometimes that in this case also there is an argument that is not mentioned here. Deposit holders are considered as other creditor. No, it is mentioned. They need to be treated at par at home buyer kind of thing and financial. They are also financial creditor. That kind of order issued by NCLT Kochi. in this case, the importance of authorized representative were both the cases, home buyer and the deposit holder. Ensure adequate representation for both people and compliance with the IBC procedures. That's all the key takeaways in this case. The Vijay Kumaran versus Thompson and Sons Builders and Developers Limited. It talks about home buyers and deposit holders. This is also a unique case. Now we come to the case number 8. The case is about the same appointment of AR only. The Pecan Trustees Limited versus Modella Textile Industry Limited. The case is admitted in Mumbai NCLT bench. Insolvency proceeding initiated as per IGC process. Application for authorized representative by initiated by the IRP in 2022. Based on that, Mrs. IP Sudha B. Navendra is appointed as authorized representative, indicating trust in her expertise. That means selection of, I put just one slide here. There they put what kind of expertise she have. See, that kind of things are there in the case. And function of the authorized representative. What kind of responsibility she need to do. That is mentioned in the order. Participation in the committee of creditor as a creditor in class. Communication with the creditor, that's also mentioned in the judgment. The key takeaway from these case, appointment of Mr. Sudha B. Navendra as authorized representative by NCLT Mumbai. Role of authorized representative clearly mentioned, negotiating a fair resolution plan, what kind of negotiation she can do in the resolution, what are other the financial creditor, what kind of role they are playing, the similar kind of things are there, and keeping home buyers informed because of AR representation. That's all there. Here, this case uniqueness is roles and responsibility mentioned in this case. Then the case number 9. The case number 9 is, I think this is last, then the new development in authorized representative or the home buyer case, real estate case, we are going to talk. The case number 9 is with the Government of India versus Supertech Limited. Date of order is 2022. Type of case is the Ego Village 2 project where home buyers are seeking representation. The fact of the case is home buyers are seeking representation. Insolvency resolution professional role that is mentioned in this case, and also IRP, that AR, authorized representative advocate for the home buyer interest. What kind of interest? That's all mentioned in this case. Same, similar like functions of whatever the roles and responsibility of AR based on the IBBA regulation, that is mentioned in this case. Participation in the committee of creditor, whether he can able to Ankit, before 10 minutes, I will share all the document. Don't worry. Already I communicated same. Before 10 minutes, I will share all the presentation, all the regulation, whatever the document I have, I will share it. Communication with the creditor, because he is the middleman in between the creditor in class and the COC. Whatever in the earlier presentation, he clearly mentioned what kind of communication he should do with creditor in class. That is mentioned in this case. Key takeaways. In this case, Sanjeev Kumar Sharma as authorized representative in Ego Village 2 project. the role of AR in negotiation, the negotiation with COC, creditor in class, the communication, that's all mentioned. Protection of home buyer interest also protected with the appointment of IP Sanjeev Kumar Sharma as authorized representative. With the AR appointment, home buyers are empowered to participate actively in key decision affecting their investment. The involvement is crucial for achieving resolution that align with the expectation and needs. These case specifically mentioned AR also. The significance and critical analysis of overall cases. Either it may be the Supreme Court judgment or NCLT judgment or the NCLAT judgment, the pioneer case, that is High Court judgment, everything, the critical analysis, if we synthesize all, recognition of home buyer rights, that is the initial three cases, the judgment reinforced the rights of home buyers of financial creditor under IBC, allowing them to participate in committee of creditor and their relevant fees, everything mentioned. Then push to real estate sector. Because of these landmark judgment, legal framework to address the grievance of home buyers, significantly increasing the confidence in the real estate market and encouraging investment. That is possible because of these landmark judgment. And precedent for future cases. The judgment established a crucial precedent for similar cases. There are 50 cases. I am going to put it in chart parts. There are 50 cases, but not full all the cases. The case name versus whom the petitioner and the appellant, that things will be there, and if you need, you can search in IBJ site, get it. We talk about only few 9-10 cases only, but there are landmark judgment cases are there. As IP, we can get those information from related with authorized representative. Positive aspects of the judgment. The home buyers' interests are the concerned. The court adjudicating authorities also concerned about the home buyer. IBVA also, because their stake is protected under the regulation, rule, code, everything, even the judgment. And also, based on this judgment, even recent amendment as a facilitator, the 1,000 creditor in classes are there, means one more, other than authorized representative, even facilitator can be appointed. That is even 2 days back, that is also came in the picture. And challenges posed by inclusion. All these cases discussed about whether the home buyers have the right, whether home buyer as a financial creditor, and developer is putting cases left and right with the NCLT and the other adjudicating authority. But now it's clear picture, home buyers are financial creditor because of these kind of cases. Potential increase in insolvency cases. I already talked about there are 30 to 35% of the total IBC cases now relates with the real estate sector. It shows the various stakeholders, either it may be financial creditor or creditor in class, other creditor or operational creditor or IP. They have trust on this process. That's why the case is now increasing. Real estate sector, that's why even the total regulation code, the real estate sector, even the amendment of Real Estate Development Act also included in the amendment. Earlier, because of these cases, because of this volume, because of these experiences, need for balanced approaches. Even the both home buyers and developers, in certain cases, the NCLT also rejected the AR appointment. There are certain cases are there. It's a balanced approach. It needs to be because it needs to be protected the corporate debtor also. Another thing is the creditor also. That is witnessed in these cases. And importance of timely project completion. Because the AR appointment with the real estate recent amendment, the timely project completion is at least still it is highly challenged, but somehow we are moving towards the timely completion of CARP. The impact of Pioneer Urban Land and Union of India case, it's the accountability, whether the home buyers are financial creditor, even the Chitra Sharma, the first case, everything based on the real estate case. Even the IBC framework itself modified over the period and still evolving. These are all the whatever we talk about. These are all the cases. Now we are going to talk about the key proposal for enhancing real estate insolvency resolution. Discussion paper of IBBA. It is put it in. I think last day to it is in November month. That's why now facilitator role based on this discussion paper one by one amendment is coming now because of this proposal. That's why we should know these proposal also. Discussion paper of IBBA. In IBBA portal, this discussion paper placed in November and they given time for comment. That comment date also, I think November 27th is the last day. Everybody given. But based on the discussion paper, now one by one amendment is coming. That's where the facilitator amendment is coming. Now we can look about what kind of points are discussed in the enhancing real estate insolvency resolution. The point number one is proposed inclusion of land authorities in committee of creditors meeting. Point number one. I think now the amendment also made already 3rd February this month. The amendment also in active now. The point number one is proposed inclusion of, that means the registration authority, regulatory authority, they are also part of the COC meeting as a participant. That means whatever the decision, because earlier date, these people are not participating in the meeting. The IRP need to go, RP need to go left and right with the regulatory authority, discussing with them, and even they may not understand also. Now it will be resolved because of participation from land authorities. They cannot come and because invitation will any COC meeting, the invitation letter will go to the land authorities also. If they are not coming in, then they are answerable to adjudicating authority. That's also that is the discussion point number one. Point number two is handling cancelled land allotment in real estate insolvency cases. How it is handled? That means there are time the initial home buyer withdrawn their application. They don't want land allotment. Then how these cases can be handled? That discussion paper also they put it in. I think now the amendment also comes based on these discussion paper. The November month, February month amendment also came. That means regulation amendment already there. And point number 3 is empower committee of creditor to facilitate participation of association of allottees as resolution applicant. This is landmark discussion. That means the committee of creditor, the creditor in class, they themselves can form one association. They can be one of the resolution applicant. That is also possible now. That's also not possible now. That's also put it in discussion paper. I think any time, I think we need to refer with that. Maybe after this presentation, we can go to the recent amendment also, the February 3rd amendment, the the government order, the IDDA order, that we can go. Now the Association of Alert is also one of the resolution applicant. They can apply for a resolution plan. That is landmark. If it is come in force, it is landmark decision. Yeah, already they invested. If they can able to manage the resolution process, then it will be well and good because they are the stakeholder. Then clarification about inclusion of interest in home buyer claimant. This is now amendment also made. November discussion paper talk about interest in home buyers claim in ARG. That whatever the interest rate 8%, that is clearly mentioned in this discussion. We can expect this amendment also came now. Representation of large number of creditor through facilitator. This is also discussed. But now amendment also regulation is there. From February 3 onward, apart from AR, there is one more insolvency professional who acts as a facilitator. But the condition is the creditor in class have 1,000 plus number. Then only we can appoint the IRP and RP can facilitate they can recommend facilitator. Facilitator also insolvency professional. And proposal to disseminate a committee of creditor minutes of the meeting to all creditor in class of real estate. Transparent communication is essential. That's where this also discussed and it is also amended also. Streamlining possession of handover in real estate project. In between the project time, the sufficient money is there in the home buyer. The project is one by one completing means earlier in IBC cases the total allotment is only possible. Now stage by allotment, even the floor one floor completed, then based on the COC approval, even the home buyer can get the handover. Okay. That is possible. That is discussed in this paper and probable solution also given. The key issue, what are the key issues? They are talking about proposed inclusion of land authority in committee of creditor, that discussed handling cancelled land allotment in real estate insolvency cases, empower COC to facilitate participation of association of allottees as a resolution applicant, and proposed solution, inclusion of competent authorities in COC meeting, actually now amended, and relaxation of condition for allottees. That means they can also participate in resolution as a resolution applicant, and the reporting of land allotment cancellation. That is now possible. This is discussion paper, but it is put it in amendment now. Classification and interest inclusion for home buyer. It is clearly mentioned. Regulation 160A for 7, 8% per annum. Now it is very it is clearly mentioned. Then there is no reference for Company Act or any other act. It is there in the IBC. This is the amendment. Now what we can do, we can go to the order. I'm showing, sharing my screen. Hope my screen is visible. This is the, based on the discussion paper, this amendment came in February 3 this month, just 2 days back. It is there in the IDBA site. Actually, it is immediate. There is no, even today onwards, third onwards, it is applicable to all the real estate cases. Handing over of the possession. Point number 4E, regulation 4E. After obtaining the approval of the committee with not less than 66% of votes, the resolution proposal shall hand over the possession of the plot. That means in between the CARB process, if the committee of creditor given 66% votes, then the property can be handed over to the home buyer. That is that earlier that regulation is not there. Handing over of the possession now possible in between. That regulation comes. That they put it in the regulation, the discussion paper. Now amendment came. And point number regulation number 16C, appointment of facilitator, where the number of creditor in class exceed 1,000. The committee may direct the interim resolution professional or the resolution professional, the case may be, to appoint an insolvency professional other than the interim resolution professional, authorized representative, any other person as facilitator for a subclass within the creditor in class subject to following condition. That means there is new blood coming in the real estate case. If the creditor in class exceed 1,000 number, home buyer 1,000 number, then appointment of facilitator. A facilitator also insolvency professional as per regulation 16C. The provision is, the condition is, the appointment of facilitator shall be complete creditor of request of appointment along with the name of the out of 1,000, because it is 1,000 plus creditor in class. At least 100 by permission to put facilitator. Shall not exceed 1. It can go up like AR authorized representative. Facilitator can go up to 5. Each facilitator fees already we discussed 20% of the fees specified in the AR, the meeting sitting fees. 20% only. Because here another here the vote, but he can be an observer between the creditors of the respective subclass for providing information. And because as we discussed earlier, unlike IRP and RP liquidator, the role of AR is something educative because he need to handle the home buyer. That's where the facilitator may be a trainer. The facilitator may be the IBC relevant provision. They can able to talk with the creditor in class. The committee, maybe the committee can add the representation and communication with the role can be added to facilitator. It depends upon the creditor in class, how many, maybe 100 plus, there are total 1000 plus. Out of that, one facilitator handling 200 or 300 means how the work is allocated, that will be decided by the creditor in class. And also regulation 30C, report on the development, report on the status of development rights and permission of real estate project. Already we discussed in the presentation. Detailed report need to be prepared by the IRP or RP. Resolution professional need to prepare development rights and permission of the real estate project need to be prepared. And there are even the MSME Act also included in this case, facilitator role, and also the real estate case. And we already talk about the resolution applicant, the 10%, the expression of interest can be given by the resolution application can be given by the association of group of allottees can be one of the resolution applicant. That's the landmark regulation. But only this will be only applicable to 1000 plus K. That is for facilitator. This case, even the home buyer, they can form as a association of allottees. They can be one of the resolution applicant. The eligibility criteria and everything remains same as the resolution, the generic, the resolution applicant criteria. And committee, there are separate committee setting up a monitoring committee for monitoring and supervising the implementation of a resolution plan. That needs to be, and also the monitoring committee need to be submit quarterly reports to. This is in addition to other compliance by IP. Quarterly report, the monitoring committee quarterly report need to be submitted to a adjudicating authority regarding the status of implementation of resolution plan. Already there, but with respect to resolution plan, these real estate projects, there is separate report other than the quarterly report. The development based quarterly report needs to be submitted to adjudicating authority. And based on this, these Schedule 1 Form G, this point also included. That is related with the MSME. This is the amendment based on the discussion paper we talk about in the presentation. I think I concluded the presentation. Now we can maybe talk about general discussion. Yeah, that's all. Anything we want to discuss? We can discuss now. I'll put up the presentation in the chat box. Let's see. All the presentation, reason amendment, discussion paper, everything I put it in chat box. You can check your chat box. Everything will be there. You can download it. Otherwise, also I will share with ICSI. You can get it from them also. Any discussion related with? I thought that there are many the experienced professionals are there. If anybody handled the real estate case, you can maybe you can share your interesting experience. If anybody handled real estate case. Yes, Advocate Prakash Pandya, please share your own experience to all the participants. It may be enriching experience. Please talk about what is the case and how you are handling. Maybe if you don't want to disclose the case name, you can keep it confidential, or otherwise any interesting observation and what kind of challenges or what kind of process you followed it, please, for the betterment of all the people. Advocate Prakash.
Sure, sir. Thank you.
Yeah.
So since the case is ongoing, I won't be able to share further details, but I certainly would share generally what happens. Uh, like, uh, like besides our legal and the human skills, the more aspect is of the human skill, particularly I found. In the case which I am handling is of a slum rehabilitation, where about 130 slum dwellers were asked to vacate the land, and then the corporate debtor started the demolishing and started constructing the building. And as you must be aware that in such cases there are two buildings normally constructed. Typically, I mean, one is a rehabilitation building. People who have given the land, who are the slum dwellers, they will be getting pakka makan, so constructed flats. And then there is a compensation to the developer by way of constructing another building, which we call the sale building, which they sell and earn the profit. Now, typically in our case, once the slum dwellers were thrown out of their place, I mean, they voluntarily vacated and the construction started partially, and then the corporator went into the CIRP. So I had real good time in dealing with the slum dwellers and explaining
Yeah.
obviously in vernacular language, and meeting some real local gundas.
Oh.
And managing the affairs. And luckily, so far, without going to the police or taking any external help, they were very understanding. But there is a lot of emotional issues attached because these are very poor people. And for them, once they've vacated their place and to get the rent, monthly rent, because they are staying in on rented premises somewhere else. So like even if they are staying in say some another chawl or another slum, there also they need to pay minimum says 10,000 or 15,000 rent for that slum. and they don't have enough of money to pay that rent, because this is now additional burden. What's normally is the situation as in any redevelopment project, that once we vacate our houses, the developer pays us the rent. The same is the situation for the slum dwellers. And because the city is under financial stress, we could not pay the rent. And there were very horrible situations, because somebody is very ill, someone was suffering from cancer, and you need to, somehow make arrangement, and we have the code which says that you can't pay, and you can't pay in priority to a particular creditor, right? All those things were there, but somehow we could manage with the cooperation of all the slum dwellers. And finally, with the help of the committee of creator as well as the suspended director, we could complete the rehab building and give them the possession. Though the rent is not fully paid, still there's some outstanding. Now that's the case, sir. I thought this might be of some interest.
Yeah. I think you are doing a social service.
No, sir, it's kind of a force upon social service. But I mean, I don't mind. Frankly, I don't mind. Yeah, it was a good opportunity to serve the people. So that was really nice. So the code and the IBBI, as a IP, I could get that opportunity, and that privilege I enjoyed of, guiding these people. And to my surprise, not many educated people will understand, but these people were willing to know what is happening, what is NCLT, what is IBC, and so I think they have very good grasp now than most learned people in the society.
How many people affected?
131, 131.
Whether any AR appointed?
No, sir.
Okay, because of these
None of them filed
government.
the claim. Sir, not a single
Oh,
person filed the claim.
okay.
It is all
Great.
purely on the word that will pay you. We are working towards it. You have an option of filing the claim. So they said nothing doing. We don't want to file the claim. What's the use? All those.
Correct.
And even
Very,
out of many flat buyers, only 6 flat buyers filed the claim.
okay.
Even they were very cooperative and supportive. But flat buyers, we can understand, sir. Normally, they have good money. And in my particular case, most of them were, only except I think these 6 people, and maybe a couple of more people who have not filed the claim. Most of them are investors, so they have sufficient money and they could wait.
Correct. Great, Advocate Prakash.
Yeah.
Anybody other than Prakash? Actually, Prakash, congratulations in this forum. You voluntarily come, and that's also normally ongoing project. Nobody interested to share. You share that thing, but I think once you complete the project, you can write some kind of case study. Maybe
Yeah.
how long that case is going?
Yeah, sir. Sorry, sir.
No. How how long it may go? Maybe another 2 years or another 1 year.
No, sir.
What's your?
No, sir. I think it will get over in a month or two.
Oh, great. Then that's a clear-cut case study for many of us.
Thank you, sir.
Yeah. Anybody want? Yeah, Ajay. Oh, yeah. Sorry. Anybody other than Prakash? Anybody handle real estate cases? Okay, I think I wish all the you have to maybe you may get the real estate cases also, and you may have the experience of AR representation also in your case, and now the facilitator, but maybe the big company only may have 1,000 plus creditor in class. Facilitator opportunity may come or not. At least the AR opportunity will come to us quickly. And thanks for your patience. It is a very challenging time also. I know I'm also IT. Everybody have their own priority. You allocated time for learning, and whatever there it itself, because of IBBA, the recent amendment also came. And once again, thank you, and you can connect maybe if anything support academically required, something like drafting the case or any support, you can reach me and John Vincent, ex-banker. My mobile number is there, email ID is there, my LinkedIn profile is there. If you want, this also I shared in the, along with PPT, it is there. Maybe we can enrich our, because the IP profession itself, the continuous learning only, continuous learning only, learning possible only cross learning happened between the IP, then only it is possible. Now many WhatsApp group, many LinkedIn, then many of the IPs are, IPEs are doing the webinar kind of things, and we can connect each other. I may get experience out of you, and the cross learning is possible. Thank you all, ICSI. Now I completed the session. I hand over to ICSI. Is there anybody?
Yes, sir. I'm here.
Yeah,
Thank you,
yeah,
sir.
yeah.
Thank you for your time and your learning, which was such a great session, so interactive and so insightful. Thank you.
Thank you. Thank you. Thank you all.
Thank you, sir.
Thank you. Thank you.
Thank you, sir.
Thank you.
Thank you, ICSI.